one person with the ID eye patch rubber limited, please unmute yourself. And I would request, mute yourself. I would request all the participants to be kindly on mute. Please ensure that everyone apart from the speaker is Mr. Ranjit Mahatani is on mute. Gaurav from our IT team, can you please, yeah, Gaurav, just is it possible to mute one ID which is appearing in from this name? One eye patch rubber limited. Uh, would request all the participants to be on mute, please. Good morning, everyone, and welcome to this session today. Take through the decisions of the GST Council and its impact analysis. So, since all of you are aware, there were a lot of decisions in the last meeting of the GST Council meeting, the 45th meeting. In fact, the press release was also 8 pages, a lot of rate rationalization, a correction of inverted and other changes have happened in the last meeting of the GST Council. So, FICCI and Dhruva Advisor LLP, we are pleased to bring for our members this webinar where we can take you through the key decisions of the council. And I'm very happy to welcome Mr. Ranjit Mahatani. He's a partner in direct tax with Dhruva Advisors LLP, and thank you, sir, for agreeing to be part of this webinar, this important webinar, and taking time to apprise all the members on what all has happened. And I think we are looking forward to the session. We're sure we are going to get good insights from you. I will also just briefly introduce Mr. Ranjit Mahatani before we go ahead with the session. Mr. Ranjit Mahatani is an advocate and a chartered accountant and is based in Mumbai. He advises on all direct and indirect taxation issues and focuses on all nature of indirect taxes, including GSTs, customs duty, and the foreign trade policy of India, and also erstwhile indirect taxes of central excise duty, sales tax, service tax, etc. And more recently, he led diverse GST assignments involving government advocacy, impact analysis, and transition support for clients in variety of sector. He has also been intrinsic part of numerous tax litigation and dispute matters across all adjudicatory and appellate fora, and represented clients before different tax tribunals and Indian courts, including writ petition proceedings. He has also worked on sectors including entertainment, banking and insurance, logistics, manufacturing, oil and gas, shipping, telecom sector, amongst other. And prior to joining Viva, he was partner with economic law practice and was with a member firm of Deloitte Haskins himself. So welcome, sir, to this FICCI and Viva Advisor webinar today. And over to you for the session. You can share the presentation and just a request to all the participants, kindly be on mute, and you can uh, put in your queries in the chat box. There is also I think the Q&A box I can't see. You can put in your queries in the chat box, and that would be appropriately taken at the right point of time. But would it's sincere request for everyone to be on mute apart from Mr. Ranjit Mahatani. Over to you, sir.
Thank you, Ira. Firstly, thank you and all of you all here at this session. So, good day to all our participants on this webinar. I would first welcome you and thank you for making the time on a Saturday to attend this webinar on the recommendations and the developments that have happened at the GST Council in its 45th meeting a little over a week ago. That was on the 17th of September. I remember it was a Friday, and we had uh, a briefing which was scheduled for 6:30 by the FM, and that did not really begin until 8 o'clock, which just shows that the agenda was packed. They had a lot to discuss. They did have a lot of time spent interacting amongst the members in the council. And finally, almost an hour and a half late, they were able to come out and make the press briefing. And then, as Ira also mentioned, there was a very long press release which was put out. Um, Thereafter, we've also had a set of circulars which have been issued. We've had a couple of notifications which have come out late last evening. So there's been a lot of outcome from this particular council meeting. And the session today, we're going to walk you through the more important ones or the more critical ones which impact business as a whole. And I do hope that we'd add some perspective and value to you as you've taken out time on this Saturday morning to listen to me. Um, Before we get down to the specifics of what was the points in recommendation or what were the points which have been deliberated upon, I think it's a point that must be brought out first, that revenue augmentation was at some sort of a forefront, or was a theme which was playing out in the minds of at least the central government finance minister. And this was on the back of the targeted revenue neutral rate of 15.5%. As I said, it was a focus area, and so there have been quite a few tariff changes, and they seem to be directed at this particular effort, which is revenue augmentation. Of course, there is other objectives, but a sort of underlying theme seems to be from a revenue neutral rate and how to come closer to it than they actually are at this moment. And some of the decisions or some of the recommendations which we are going to sort of discuss a little later are concerning inverted duty structure. And again, that seems to be on the back of the revenue neutral rate that is sought to be achieved. As you would be aware, that pre GST's introduction, it was 15.5% that the committee had recommended or had brought out in its report, and it's far from there, and therefore we are finding various changes that have been proposed. Um, it appears that a much stricter financial and fiscal regime in terms of re restriction of input tax credit, or then certain measures which are in terms of punitive measures, are something that the GST Council have been mulling over, and it seems that it would also come as part of the group of ministers' task and terms of reference, and so they would have ways and means to improve the compliance and augment revenue. So what we are therefore going to likely see in the next few weeks from now is that the eye is going to be on e-bill and how the e-bill systems are working out, the e-invoices, the FASTags data, and strengthening overall, just seeming to strengthen the institutional mechanism for sharing of information and intelligence, and so as to make a greater enforcement of the provisions to augment the GST collections that we have. Although in the last few months we have crossed the 1 point odd lakh crore rupees per month, I think there is a clear cut understanding that the collections must be larger than that, and so steps will be taken in that direction. Um, Another key, I would say there were two other key, or there were two key issues which were on that agenda item on this council meeting. One was, of course, the ticklish issue of compensation cess. We will discuss that in some detail as we go along. And the second one was on the inclusion of petroleum products in the GST fold. as is now common knowledge that that is not a decision which has been reached, and it looks like it will be some time away before such a decision can be reached. Even though you and I are shelling out quite a sizable amount of duties, in terms of petroleum products duties and taxes. While there was so what we were told, and this information is maybe not very much verified, but we there was a sense that the council's agenda was a packed one, and by some sort of information, it seems that they had more than 50 odd items in there. But I was at a personal and a professional level somewhat disappointed with some key issues not being there, and the most prominent one, in my view, is the fact that we don't have a GST appellate tribunal. We are now 4 years into the GST regime. There are some challenges which have been raised, and these are now in different courts, including the Supreme Court. But as disputes, as litigation is now beginning to rise, and we are now going to see the need to file appeals. The lack or the missing GST appellate tribunal, I think, is a very important area which needs to be attended and attended to quickly. It would be something which the council must take up, in my view, at the earliest it can in the sessions that it comes up with henceforth, because not doing so means that you're taking up matters into the High Court and clogging the High Court up, or you are basically not having uh, an efficacious appellate remedy for the taxpayer assessee, and that again is an unfair situation to have them in. So, with these comments, I would like to start the slide that I have for you. Um, some of the highlight points of this particular meeting that we had. First physical meeting after the pandemic outbreak. The discussion on extension of compensation cess and inclusion of petroleum products, as I mentioned, these were important agenda points. And in some way, there is some resolution, some recommendations, but not in all respects. A focus area, if there was one area where there was a focus from the council's perspective, I think it was the inverted duty structure and the products and issues where inverted duty structure is impacting the industry. We will have a discussion on that particular aspect in detail in the next few minutes. Another aspect was the resolution of trade-related issues, and there have been a set of steps, measures which have been announced, which will be announced, I'm sure, in the next few days about resolving trade-related issues as we go along. And the last of the highlight points would be where I mentioned revenue augmentation. So data analytics for increased compliance, for detection of revenue leakage. These would be in the coming months, in the coming period, quite a focus area from the council's perspective. And I think given the enforcement tasks that will then move down to the field formation, we'll also see it at the departmental level as things progress from here. So first, touching upon the rates, I think it may not be of quite great relevance to everyone today, but just to sort of bucket it and put it up out there. Concessional GST rates on certain COVID medicines has been changed and amended in some way or the other up to the end of this year for a few of those medicines. While that's the case for medicines, the medical equipment concessional rate, which was to run up till the end of this month, which is September, will not go any further. At least at the moment, there was no announcement around it, so they would therefore seemingly not have the benefit of a concessional rate after September. There's been a reduction in the GST rates to 5% on certain COVID related drugs up to the end of this year. There's an exemption on for from IGST on the import of certain specified medicines for personal use, which, if you would recall, there was certain high value equipment and medication which was very expensive. There was some crowdfunding efforts which were taken, and it turned out that there was quite a bit of a amount of duty that needed to be paid, and that became a roadblock of sorts. And so there was an exemption which was, brought in for that purpose. A specific drug for cancer has also been, subjected to a rate reduction with effect from October 2021. And in a nutshell, these are the either medication or COVID medication or certain other medication related rates that were announced upfront for rate changes. Okay. Taking up the next set of rate change recommendations that we have, some of them are quite interesting, and I'll talk about that in a little bit detail as compared to some of the others. This particular slide that we have deals with the changes in respect of goods. And I think the important one, and when I say important, is more from a perspective of how the legal perspective around it is, not necessarily from the commercial side of it, is the one concerning ores and concentrates of metals such as iron and a few other ores, where the rate has to now go up from 5% to 18%. We'll dwell on this in a bit in detail. Similarly, for specified renewable energy devices and parts, it goes up from 5 to 12%. There's an interesting change in the context of cartons, boxes, bags, packing containers of paper, where 12 or 18, as the case may be, now it will go up to 18%. And I must share that a day or two ago I had a little bit of a frantic call from some client to say that oh, I don't know when this rate change notification will come. I need to make changes to my system, to my SAP module as well, and I'm not sure whether I'm covered by this particular category of cartons, boxes, etc. So what should I do? I said the only thing you could possibly do is wait, begin your process, but don't turn the switch on any change, because the notification is what governs it all. It's very difficult to say what they cover and what they don't cover by the generic description that's there in the recommendation. So you'll have to just wait it out and watch.
Sorry to
Uh,
interrupt, sir. Sir, actually, I think the presentation is not visible now. It was visible earlier. Can you just share it again? It's not visible currently.
yes, I shall do that. How about now, Ira?
No, it's not visible right now.
Okay, let me just.
Yeah, sure. Yeah, now it's visible.
Okay. Yeah, the other important one or change, which is in respect of, again, because of inverted duty structure of sorts, is the railway parts, locomotives, and other goods in Chapter 86, where the rate goes up from 12 to 18%. And this clearly looks to be directed at the tackling the issue of inverted duty structure. As I mentioned, the notifications are yet awaited, and I would believe they should be out anytime soon, perhaps even this weekend. These are some of the changes which are in respect of services. Um, let's maybe walk through some of them. The validity of the GST exemption on transport of goods by vessel and air from outside from India to outside India is extended further. This has been there almost since the time GST came in, and it continues to be exempted and ameliorated. A change which may seem quite irrelevant, but has a lot of perspective to it. So the national permit, when it's granted, is to goods carriage is on a payment of a fee is also now going to a nil rate from an 18%. It seems the two reasons why that's happening is because the goods transport operator would effectively not have an output tax there under the reverse charge. So if this tax was being paid by them, it was becoming a cost in the system. The second reason seems to be that the granting of a national permit is a case of a function by the government, by the state or the central government, whichever it is, and that is not a service in the language of it is, in the sense that it is understood colloquially. And so it's not a supply that should be brought to tax, and therefore the grant by the government of a national permit to goods carriages is brought down to a nil rate. Another interesting one is where licensing services and the right to broadcast and show original film, sound recording, radio and television programs has been increased to bring the rate up from 12% to 18%. And this is to bring parity between distribution, which was at 12%, and licensing, and between distribution activities, which was at 18%, and licensing, which was not at 18%, was at 12%. And therefore the disparity, because in that chain you had one level which was at 18% and another level which was at 12%, and that now has been addressed by virtue of this rate recommendation. Again, in the context of these services and these activities, also the notification in specific is awaited. It probably will be out anytime soon. Okay. As I mentioned earlier, inverted duty structure took quite a bit of mind space, took up quite a bit of, I think, time on the agenda. And there are various parts to it, which we are noticing on our screen now. I'm going to talk to you about each of them in some detail. So the first one is in the context specifically of the mining industry, which was mining for iron ore or certain other ores, and the rate that was ordinarily being applied was the rate which applied to the ore for the purposes of that mining activity, and so it tended to be 5% on the outward side for this mining industry. Whereas the royalty that was charged by government, or the dead rent that was charged, or certain other fees and amounts that were charged to get and grant the license to undertake the mining activity, was subjected to 18%. So there was a clear-cut 13% inversion in their structure. And this was quite a difficulty that the industry was facing, and not now, for quite some time. And in that context, the GST Council took cognizance of this point, and they were able to understand and change the rate on the outward side. That was one of the suggestions which was made, to correct the rate from the outward perspective. So if there is the inward at 18% on the royalty that the mining sector paid, now they are paying 18%, or they will pay 18% even on the outward side. And so the feed to the industry in the manufacturing side will be at 18%, and it would take care of the inversion, which this inversion was primarily occurring because of the royalty amount and the cost that it had. Now, while this is a good move, this is a move that the industry had sought for, and for quite a bit of time. There has been one clarification which has been in the parallel issue. And this clarification says that the provision of grant of mineral exploration and mining rights attracts GST at the rate of 18% from the date GST was brought into force, so July 1st, 2017. Now, the question that really pops up because of this is that notification 27 of 2018, which has come into effect from 1st of January 2019, um, that particular notification changed the rate in a very specific way from 5% to 18%. And now, what will then therefore be the situation where a rate change was made by a notification with effect from January 2019, and it became 18%. And the government today says that no, we intended it to be from the, when I say government, I mean the council now will recommend, and so a clarification. We intended it for it to be 18% all along, and from July 2017. So what happens to that gap period of July 2017 to December 18? I can share there are variety of situations that are facing the sector on this point. There were several who paid it at 18% for this gap period and sought refund. They are in dispute. There are several who paid it at 5% on the view that it's the right rate to apply. It's 5%. and so they are in dispute because of the demands raised. Uh, these sort of demands or refund rejections are all sitting up across and waiting for adjudication or in appeal at first appellate level. With this particular clarification, I would assume that all the authorities, whether in the adjudicatory side or in the appellate side, would take a uniform view and say it's always been 18%. So if you've got your refund, please pay it back. If you have a demand, we are hereby confirming it. The question that really remains is, can that circular override that notification? Even if it was the intent, even if it was the intention which was not really brought out very clearly previously, can we have the notification watered down by virtue of this clarification? That's something that we will have to wait and watch and see how that really turns. Uh, in the context of textile and footwear industry, there's been a very long-standing issue of inverted duty structure. And at the 43rd Council meeting as well, there was an agreement that there must be redressal of their issues and of their inversion in their structure. And accordingly, from the 1st of January 2022, we will have the inversion issues addressed for these two industries. A group of ministers will be formed to examine the impact of the inverted duty structure on these major sectors and thereby correct the problem of the inverted duty structure and rationalize the rates, so that wherever it is necessary, the review of the exemptions occur while keeping in mind revenue augmentation. Another of the areas where I mentioned earlier also, the rate was increased and purely it seems directed at the inversion situation is for the railway wagon and locomotives and parts manufacturing units, where the rate goes up for those Chapter 86 products from 12 to 18%. Eh, uh, when I mention and talk about inverted duty structure, how is it that I cannot discuss the Supreme Court judgment which came out earlier this month in the context of VKC footsteps and the other cases from the Gujarat High Court and decisions from the Gujarat High Court and the Madras High Court. The Supreme Court, as I would just maybe summarize, continues to maintain that the distinction between goods and services, and thereby grant of refund in case of an inverted duty structure, is a matter of policy. The government has the latitude, the council has the latitude to decide in manner and form and how, in which cases they would like to give the refund and not give the refund. And respecting that, the Supreme Court has quite clearly said that it cannot, find a reason to interfere with the view that was taken by the Madras High Court, and which means that there is no refund capability for input services that go into a inverted duty structure. The Gujarat High Court's decision was fobbed off, and the Madras High Court's decision was endorsed. Finally, in the context of the formula, which is there in Rule 89, the Supreme Court said that there may be some anomalies, there may be some sort of mechanics which need to be revisited. And the question that really, and therefore directed that it be considered by the GST Council. The question that now comes up is the group of ministers that is going to be formed, which was very soon after the Supreme Court's view, in judgment and view in this case, whether their terms of reference will also include and require them to take up this particular direction from the Supreme Court, that the formula needs to be looked into and the tweaks that are necessary are taken up and made. It's a matter of time that we will know soon enough what their terms of reference is for the group of ministers, and how they're really taking up this direction from the Supreme Court. Compensation says, maybe it really doesn't impact us, but fact remains it really impacts us, because at a macro level you're looking at whether the cess continues, how it continues, and therefore and thereby the impact on us in a consumption mode, not necessarily as tax payment that we need to make for most of us, but as a consumer this would have a direct bearing on us. Uh, the long and short of it is like this: that 5 years was the time frame for which lack in revenues was to be made good by the central government, and that 5 years will run out in June of 2022. This was the sort of pitch on the basis of which the states were brought on board and the GST regime was really introduced. Everybody was onboarded by saying that if you have shortfall in 14% incremental growth year-on-year basis, you would be compensated by the state. Now, we all are witness to what happened in March 2020 and onwards due to the COVID-19 outbreak and the pandemic. And there was a deadlock at one point in time. The states and the center were then able to agree upon a particular mechanism. There was a borrowing plan which was put in place, and there was a back-to-back arrangement which worked out. Now the situation is there has been a recommendation, and not now, but in a previous meeting, that the compensation cess should be continued, uh, essentially, and that is for the reason that they have to repay the loans, the interest on those loans, and make good all of that borrowings that has been done. So the clear messaging that has now come through is that compensation cess will continue for the purposes of repayment of those loans and those borrowings and those interests to service all of that, and no amount or form of compensation or shortfall is to be paid to the states. So the states will not have the ability from June 2022 onwards to be protected by the center saying that your shortfall will be made good by us. That line is drawn at June 2022, and from there on, it's only going to be compensation cess collection for the purposes of servicing those loans and arrangements which were made in the given window, and so as to overcome that borrowing cost. There was quite a bit of discussion, deliberation on this point, and therefore there was quite a bit of time and face time spent by the finance minister when making the briefing post the session of the post the meeting that the council had. But I think it's now abundantly clear that this is where we are. A connected point, in a way of speaking, is the willingness or non-willingness of then the states to bring in petroleum products, because at one hand there is a loss of revenue by the virtue of the protection being taken away for failure in the growth. uh, Whether then they should give up their right to tax petroleum products. And as we can see, the outcome is that compensations will not be paid to the states, and the states have, it seems, all unanimously spoken that petroleum products cannot, therefore, at this juncture at least, be brought in and brought into the folds of GST. As a result, when they clarified it, what was the situation is that the Kerala High Court had directed a consideration of this particular issue and topic, and the finance minister therefore went on to clarify that because of that reason, it was a matter of an agenda item, and once that agenda item it was discussed and it was unanimously sort of concluded that it cannot be brought in at this juncture. That's the reporting which will go back to the Kerala High Court, and the matter will then be disposed of as the High Court deems fit. So a it may seem like we are talking about only compensation cess, but I think it's important to understand the dynamics are actually quite intricately linked with a lot of other things, and I think the cess has to be always seen with the taxation on the petrol products. So we mentioned that the 42nd meeting in October 2022 had talked about extending it into the further period. Okay, I think this is a particularly dynamic issue. We've had a large deal of controversy on the intermediary services. And in fact, it's a matter of a very large clarification by by the circular that has been issued in this case. Quite a long one, I must say, and I must compliment them for having actually gone out and tried to put down different situations with illustrations and explain why and what is the scope of intermediary, how and where it would really be a case that intermediary applies as a service, and where and when it doesn't apply. And by that logic, there is a conclusion as to whether there is intermediary or not. So compliments, of course, to the Central Board of Indirect Tax and Customs on having put across such a elaborate and descriptive clarification. But let's take this up at a bare bones level. So an intermediary is someone who is arranging or facilitating a supply of goods, or services, or securities, and it excludes, by definition, what we are now talking about is the definition. It excludes a person who supplies such goods, services, or securities on his own account. The question always comes up: what does it mean? What's on your own account? What is the situation of arranging or facilitating a supply of goods, services, and securities? Is the service tax law of any relevance? How should we interpret it, and so on and so forth? um, why this became relevant, why this question is relevant, is because in the context of exports, the place of supply for an intermediary is the location of the supply. So take, for example, a supplier sitting in India providing services to someone overseas, earning foreign exchange, effectively, so-called, putting the service into an export stream. But because the place of supply is defined by law to be in India, there is a inability to classify it as export, and therefore there is tax. Now, in any cross-border transaction, the party on the other side of the border is going to say that, look, it's your tax from your nation. You deal with it. You bear it. I'm not going to sort of recompense you for that. That's your cost. And so the exports began to suffer because of that, or have suffered for quite a bit of time now because of this particular sort of position. And therefore this issue becomes quite a prominent one. Now let's just also look at the history over it here. In the service tax regime, and this is before the place of provision of service rules in 2012. There was what we had, the export of service rules 2005. And this controversy was already visible even there. May not have been defined as intermediary or explained as intermediary, but it somewhere had its roots right there. Uh, the CESTAT in Bangalore, even in 2008, a decision in 2008, had clarified that such a situation does not become a case of non-export. They considered it to be export, where the service was supplied from India to a person outside India, and by virtue of the fact that it was delivered outside India, and what was delivered and how it was delivered was what was at the heart of it, they said this is an export. There was maybe not so uh, rigorous provisions which needed to be looked at and tested out, and so they were able to come to that conclusion with the export of service rules. In the context of the place of provision of service rules, the POPSR, which came in 2012, there again the GST law was where it was set apart, set up in effect, because the POPSR said the place of provision of a service under the service tax regime is the place again where the supplier is. So as we see today in section 1388B, for a supplier of an intermediary services was exactly what was there in Rule 9 of the place of provision of services rules. And therefore, the difficulty what was being faced since 2012 has sort of been given birth in that period, and from there on it's continued. In that context, we have a set of advanced rulings in the GST regime, and we've had a set of decisions in the pre-GST regime also. And as you will see, there will be a wide swing in the views that I'm just going to walk you through in the next minute or so. When we consider sales, promotion, and marketing support services, when we looked at back office, administrative and support functions, we looked at marine consultancy and support services, whether it was profit sharing from an advertisement sale, whether it was pre-sales technical support services, medical consultancy of some sort, referral services for certain college admissions. In all these cases, across the board, as you would see, different states in their advanced rulings, or even in some cases in the appellate function, have said that these are all of them on your screen are intermediary services. So without making a distinction of whether you consummate a contract, you are not consummating a contract, you are a subcontractor, you are a facilitator, how and what is the arrangement between two parties or three parties, not giving enough weightage to all of those aspects, simply concluded in each of these cases that there is an intermediary, therefore export of service benefit denied. In all of these cases, and there are many more which I have not listed here. At the same time, in in certain cases, there were situations where the view was not that it was intermediary. So there were some advanced rulings which have said otherwise in sales promotion and marketing, as you see the first one on your screen. And then in the pre-GST regime, and as I showed you, the service tax law was something which was then adapted into the GST regime as well. The situation has been that whether you look at freight forwarding on a P2P basis, brand promotion, market research, payment processing activities, referral services again, were held not to be intermediary. So as you can see, there was a clear division in views. There was a decisions on both sides of the table, and really this was quite a chaotic situation from the time that we've had intermediary as a concept. And in that context, uh, I I think the circular is really, the setting for that circular is. Now, what has happened in the case that we have now by virtue of this particular clarification, I'll take that in a moment. Um, but let's just, also just let me mention about two other developments which have occurred along the line. We had the constitutional violence which was challenged by the Material Recycling Association of India in the Gujarat High Court. The court held that there was nothing that needed to be read down or set aside or quashed or any such thing, and so the wires were upheld. There is a review petition which is pending. In Bombay High Court, in the Dharmendra Jani case, which was again procurement and solicitation type of activities, there was a split verdict between the two judges, and now the matter is before the third judge for a sort of decision as to the majority. So there we are sitting with litigation on this very same on this very topic. There was a circular back in 2019 July, uh, 2 years ago, which sought to address the classification on ITES services and as intermediary, and then it was withdrawn 5 months down the line. As we can see, there has been quite a bit of history to this particular topic in this subject. There has been developments which have gone in both directions, in favor of revenue, in favor of the taxpayer. And so, in that context, the circular is quite welcome. Before I hit the circular and tell you about it, I think it's quite useful to look at what has happened across the other jurisdictions where the concept of intermediary has actually been brought in from. So in the European Court of Justice, in one ruling, they said for an assessee to be called an intermediary, the opportunities for conclusion of such contract, making a contract or with another party, or negotiating in the name of and on behalf of a client must be in existence. And this is very important. I will show you why in a moment from. In the UK, in respect of a financial intermediary, they gave out a set of guidelines and mentioned that when you are undertaking preparatory work for the completion of a contract for the provision of services, whether it is completed or not, you would or would not fall into an intermediary. It was one test to look at. Canada, in another ruling, in 1997, arranging for a service does not mean the service of recommending, advertising, or marketing alone. So when I provide a service by myself to my service recipient, and there is no three-party sort of equation which is formed, and I'm merely recommending, I'm merely advertising, or I'm marketing, then the term arranging for service should go beyond the activities of merely referring or introducing one party to another for the supply of a financial service. So if it doesn't happen that you go beyond just recommending, just marketing and advertising, you cannot qualify as an intermediary, is what was held in this particular ruling. Now, what do we have here in the circular which has come up, which has 159 of the 2021? The factors which the clarification puts out is there should be a minimum of three parties. two parties are service provider and service receiver. There is no question of then becoming an intermediary. There must be two distinct supplies, which is there must be that supply of goods and services and securities which the intermediary party must arrange for or facilitate. So if there is only one supply and that supply is the only one you want to classify as intermediary, that would not be correct and any more possible by virtue of this notification. It stands very clear. Uh, you should have the character of an agent, a broker, or such similar person. It's also clarified that you cannot have a person who makes a supply on his own account. So when you have a two-party arrangement where one party is making the supply on his own account, then there cannot be a case for an intermediary. Thankfully, also clarified that subcontracting for a service is not an intermediary service. And so, by virtue of these factors, one would have to look at each transaction situation and come to a conclusion as to whether, in your case, in your fact, you are an intermediary or otherwise. Okay. As I mentioned earlier, compliments to the CBIC for having put out a very comprehensive circular, including in putting out 4 illustrations as to where and how they consider an intermediary to be present or not to be present. So when you're identifying a potential customers and finalizing contract, and I think the focus is on the word and finalizing the contract. Okay, so the word and is very important in this situation. That's when you will become an intermediary. So what you are doing is not just making a recommendation, as we saw in the Canadian ruling. You're not just making a recommendation and saying, "Oh, here is a sort of potential for you. Please go out there and use this link and use this connect that I have given you. It's for you to go and see how you want to explore it." When you go one step forward and do more than that, and if effectively conclude the contract, negotiate the contract, and close it out, in that situation, there is two services or two supplies. One is your supply as the arranging or facilitating party, and the other supply, or which will become the prominent supply, whether it's goods, services, or securities, which the other party will make to your client as well. And so you become an intermediary. And so if you are in the export situation, you will not be able to be zero rated because you are an intermediary. Your place of supply will be in India. A very clear-cut clarification of subcontracting a portion of the software development activities is not intermediary because this is two-party arrangements. There is a singular supply in that sense, and so it cannot be looked at as an intermediary. That's what illustration 2 clarifies. Uh, Identifying potential suppliers and arranging the interstate supply. So if you would simply stop at identifying it, that would not become an intermediary. But where you are going further than that and arranging for it to occur and consummate that sort of arrangement, then you would qualify as an intermediary, as what has been clarified here in illustration 3. Illustration 4, that's the last of the illustrations that has been put out, again makes a very well understood conclusion from the taxpayer side, often disputed by the department, that outsourced customer care activities cannot be, is not an intermediary services because you are effectively, once appointed as a customer care unit, you are supplying your service at the behest of your client, only delivering it to a party which they nominate. So the supply is between you and that particular client of yours. And it's only that its consumption occurs at a different hand. And by virtue of that, there is no three-party arrangement where there are two services. It is just one service, and that is the customer care service that you are providing. And so this cannot qualify as an intermediary, is what has been clarified. I think they've made quite a large attempt at clarifying the issues around intermediary, and this will go a long way in putting to rest a lot of controversy. Several of our clients have also reached out and talked to us since the time this has come out to see where and what their stand now is from here onwards. Um, Taking up the next point on this establishment of distinct person, uh, pardon me for taking it up in this very technical way by putting out several sections, explanations, and whatnot. But the situation actually was maybe I would say twisted to be made into a case for making a demand. The simple position was that uh, a unit in India as a subsidiary company, for example, of a foreign company overseas, when they make supplies between each other of services, would that be a case for an export or not? The reason why this sort of dispute came up was because the IGST provisions to qualify as an export of service had a clause or has a clause that the supply of service and the recipient of service are not merely establishments of a distinct person in accordance with explanation 1 in section 8. And what does that say? That establishment in India and any other establishment outside India, then such establishments are treated as establishments of a distinct person. So somewhere out there in the tax department, it was believed that there is a case here that between a company and its subsidiary, or vice versa, a company in India and subsidiary outside, and there is a provision of service, you are distinct persons hit by this explanation, and so the benefit of export cannot be enjoyed by virtue of not satisfying clause 5 of the export of service requirement. This was not the right position, very clearly now brought out by the circular. The fact is that they are two different persons. One is a person formed and incorporated under the laws overseas, and one is formed and incorporated under the laws in India. They are distinct legal juridical persons, and that's what has been recognized. On that basis, it has been clarified that there cannot be a denial of that export status in such situations. They are not establishments of a distinct person, and so zero rating is possible and permissible. Perhaps the confusion may have come because what happens when you look at a case where a branch and a head office, or two offices which are agencies of sorts, or one is a rep office of a foreign company, and do these then have the status of establishments of a distinct person? The answer to that is in the yes. And but for that, there is a separate sort of exemption notification which applies and which has its impact, assuming or where you satisfy the place of supply being outside of India. So the clause 5, which is the supplier of service and the recipient of service are not establishments of a distinct person in accordance with explanation 1, will not come in your way as long as you can establish that the place of supply is outside India. I'm talking in the context of branches or an agency and the head office, or a rep office and the main office. And in those cases, you will still be able to get the export status. This is not what has been clarified, but it's been a position which has been standing for a while now. A practical sort of issue which has been there and which has been troubling for some time now is where you have the rule in 138A that you should carry the bill, invoice, delivery challan, and whatnot. Whereas the rule 138, sub rule 2, which is basically e-invoicing and the QR code based invoice with the embedded IRN number, it may not be necessary to carry it, and it may be produced electronically for verification when it is so asked, in lieu of the physical copy. So the clarification now therefore addresses it to say the ambiguity is between rule 138.1 and 2. The field officers were insisting on carrying on the taxpayer or on the conveyance carrying the physical copy of the invoice, and it's now been clarified that if the invoice is generated as per 48.4, which is an e-invoice, then there's no requirement to carry such a physical copy of that tax invoice if the QR code having an embedded invoice reference number can be produced electronically. So this is a beneficial clarification and is quite welcome. Although it does not go fully and cover a case of a delivery challan or a bill of supply, nevertheless it does make a somewhat ease of the fact of how the paperwork has to then be undertaken. Export duty, a issue which has a interpretational angle to it, and I think this is again a welcome clarification and a right clarification. So certain products suffer some export duty, primarily because the government would like to discourage the export of these items. So iron ore, for example, from time to time, tea, coffee, etc. So there's a provision in the Act, which is the refund provision in Section 54, which says that provided that no refund of unutilized input tax credit shall be allowed in cases where the goods are exported out of India are subjected to export duty. Now, this issue of subjected to export duty is what became matter of debate and also matter of the clarification. So, in the Chowgle and Co. advance ruling from Goa, the tax authorities considered nil also as a rate of tax and said that even when it's nil, it is subjected to export duty by some reasoning, and therefore the benefit or sorry, the refund cannot be allowed to you because you're covered by this proviso, which says that no refund of unutilized ITC can be given when you are under a nil rated export duty as well. Uh, on the 8th of September, the Orissa High Court actually issued notice in one case where there was challenge to instructions of 2021 June, and which have reiterated the point that where export duty is at nil rate and not exempted, the goods are to be treated as being export duty paid, and refund cannot be allowed. So in June 2021, this was the sort of set of clarifications. And the Orissa High Court in September 21, a week or before the meeting of the GST Council, has issued notice. But I think lo and behold, we have a clarification, which, as I said, is logical and quite the right thing to have put out as the apex body, where refund of unutilized credit is restricted only if they are subjected to export duty. So it actually has to bear that export duty. And so by corollary, refund will be allowed if you are not subjected to export duty, if you are nil rated, which means that the advance ruling is improper, which means that the instructions that were issued in June of 2021 are not the right view, and where goods were exported, where goods suffer export duty specifically, were otherwise exempted. So while you may have an export duty, but you're otherwise exempted, again, you can enjoy the refund from of unutilized ITC. As I said, welcome clarification, and it's on the back of quite a few developments of very recent times, as you can see. Some key proposals relating to ITC, I think these have, they can all be discussed at quite some length. I'll quickly try to, sum it up in a short fashion. The timeline for availing of input tax credit in respect of a debit note. In the case we have is where section 160, 16(4) was put out the position that ITC in respect of any invoice or debit note cannot be availed after the due date of furnishing of the GST return for the month of September or the annual return, whichever was earlier, following the end of the financial year to which such invoice or debit note pertains. So the question came up is, do you go back and look at that invoice which is underlying that debit note and the date for that invoice, or do you look at the date of the debit note? Because that has a bearing on your ability to take or not take credit. The Gujarat Authority for Advance Ruling in a case in iTech Plast held that you have to look at the invoice date. That's what is the key thing. Even if the law was amended, which it was from 2021, even if it was amended, you cannot delink it and go away from the invoice date, is what the advance ruling in Gujarat held. And in that context, it then therefore denied the credit. This clarification, which has now come through, is again quite friendly from the taxpayer point of view, and it showcases the right approach and mindset that the date of issuance of the debit note shall determine the relevant financial year for purposes of section 16(4), and merely because your invoice is predating in quite a bit of time and does not relate to the immediate period, that does not mean the credit will have to be denied. So, like I said, taxpayer friendly and therefore definitively welcome. Another welcome clarification is the interstate transfer of unutilized cash ledger balance, where you have CGST and IGST. Of course, this is only from the central point of view because the states are independent and separate, and so you cannot have states moving their credit balances from one to the other. So the clarification is that it addresses that situation, which is the movement of interstate cash ledger balances. and the mechanism has now been sort of provided for and notified. And this will become quite useful in situations where there may be a closure of business and there may be a balance lying, or there may be for some other reason a closure of the registration for whatever reason, and there is some cash ledger balances lying. It would make it easier now. Instead of just seeking a refund outright, you have a movement from one state to the other, and it becomes readily usable at the destination state. um, a restriction on the filing of GSTR1 and its impact on ITC. I think the one area which has been somewhat subject to modification at a lot of times, on a lot of occasions, is that concerning input tax credit, uh, where there may not have been a payment made by the supplier, or there may be a delayed payment by the supplier, and then how does it impact the receiver? So Rule 59.6 has been amended with effect from 1st January 2022. A supplier will be restricted from filing of GSTR1 if his GSTR 3B is not furnished for the preceding month. This used to be 2 months now, as of today, and now it will go down and become only 1 month. And therefore, this amendment will clearly impact those parties which put up something in their GSTR1 and did not go about filing their GSTR 3B. Whether that will result into a situation of them being able to file their future GSTR one, the answer would be no. They wouldn't be able to until they've gone and sorted out their 3B for the past period, which will impact then the next month or the consequent months supplies and the ability for their receiver to take the credits. Um, Here's another one which is going to have a bearing on businesses. Sorry, can we have you on mute, please? Yeah. So restriction on the ITC to be availed on invoices or debit notes which are appearing in 2B. That's the clarification, and that throws up itself a point of whether 2A or 2B, which is the right one. As you'd be aware that 2021 Finance Act introduced a subsection rather, which is yet to be notified, which is that the details of the invoice or debit note, which is referred to in clause A of that section, has been furnished by the supplier in his statement of outward supplies, and such details are communicated to the recipient of the service of such invoice or debit note in the manner which is given in 37. Now the GST Council has recommended, and by virtue of a clarification, it'll now come through in amended form, that after the section 16(2)AA is notified, Rule 36(4), which you will recall, limited credit by way of a 5%, 20%, and then 10% or 5% of the match credit, will be amended to restrict the ITC availment only on invoice or debit note furnished by the supplier in GSTR1 and communicated to the recipient through 2B. Now, the first thing one notices is that is it 2B or 2A that is relevant? The council's clarification is that it's 2B and not 2A. So the dynamic one in 2A is not to be considered as per the council's recommendation. And the restriction in effect in 36(4).
English knowing people is there?
Sorry, can we have
English wala ko? English speaking.
Would request you to unmute, Mr. Anitrandan. I think you are on unmute.
right? Yeah. So 16(2)AA, the recommendation is after it is amended, will be also amended. Sorry, Rule 36(4) will be amended to restrict the availment only on such amounts which are there in invoice or debit note, which are furnished by the supplier in GSTR1 and communicated through 2B. There is a maybe question as to the communication should be in to B, or is it supposed to be through some other way? Because Section 37 says something else. That's another matter of maybe interpretation. We'll not sort of dwell on that at this point. The last of the points on ITC related amendments or proposals are where they subsection 50 subsection 3 is to be amended and retrospectively to provide that where interest is to be paid in a case where ineligible ITC has been availed and utilized, not just merely availed, then the rate applicable will be 18%. So the clarification is a position which has, been around in the pre-GST regime in Senvat law. People will recall there were a set of judgments, including from the Supreme Court, on when I avail, when I utilize, is it avail and utilize both? How should it be looked at? How should it be interpreted? And then there were different sort of thoughts also coming out of some high court subsequently. The GST law we all expected would have said that if you avail it but don't utilize it, should not charge me interest. There was certain judgment which went in the other direction, but now the council has said that at all times it was always intended that, and therefore the retrospective amendment, that 18% is the tax that will be applicable for those situations where you avail and utilize. So merely availing will not let you have the interest consequence, is what is one can make as a conclusion from this, and I think that's a very useful conclusion that we have. The next topic I have is in respect of e-commerce operators. This is a quite a topic by itself, and we can spend quite a long period of time just maybe deliberating and discussing this particular topic. What really was happening, and that's why this becomes an important one, is that in certain situations, an e-commerce operator was required to collect tax at source and deposit that with the government. And that tax at source was collected at a nominal rate 1% from the supplier, and put into the government treasury. At the same time, the supplier was also obliged to be registered and paying tax at his own end. But what invariably was happening was that there was a gap where, when you looked at the collection from the supplier's point of view, computing it from that end, there was a definite shortfall when you backworked the tax collected at source. So if I collected tax at source at 1% of a sum X, then what would have been the full tax on that situation? In that case, there was a gap which was found, and I think there was several states which the data for they were monitoring for a few months, and once it was an established sort of trend that there was a gap, and it seems therefore there was some leakage. There was the need to address that leakage. And to address that leakage, what is the sort of solution they've come up with is what I'm just going to describe. But let's first just look at the concept of e-commerce operator, and then it'll be we can discuss what is it that the proposal is. So in terms of 9(5) of the CGST Act, there are categories of services, the tax on which is to be paid by an e-commerce operator if those category or services are notified. The provisions, then what would happen is, once you are a e-commerce operator, and by definition you qualify as one, and you're one of those notified services, then all the provisions of the law apply to such an e-commerce operator, as if he is the supplier liable to make and pay the tax for such services. Now, what it really means is that you step into the shoes of that supplier for whom you are the e-commerce operator, and you discharge his tax liability. So in the case where you were transportation, where there was supply of transportation of passengers by a radio taxi, motor cab, maxi cab, motorcycle, for example, the Olas and Ubers of the world, the tax was actually paid by the e-commerce operator, not by the driver partner of the particular service provider, of the app operator, I would say. Although it may seem otherwise, And then between the two of them, there would be an arrangement of how the tax is to be paid and discharged, what the driver would take back, and how would the deductions would be, and etc. That was one case. Another case where this e-commerce operator situation is applicable is when you have bookings made through Airbnb or Booking.com, for example, where accommodation services are the supply, and except where the supplier was liable to register by itself. The third case, and in the new age sort of world, you can look at it as an urban company type service where certain housekeeping services such as plumbing, carpentering, etc. are provided. And when you receive this through the app, there was a requirement of the law that urban company, for example, would be the e-commerce operator, and he would be, or that entity would be obliged to collect and pay the service, the GST on that service, which is provided by the underlying service provider. Now, given the gap that was noticed in the context of restaurant service, primarily restaurant services, and of course also in the case of transportation of passengers by any type of motor vehicle, but the data analytics was more revolving around the Swiggies and the Zomatos of the world, and where restaurant services are provided, there they felt that the gap is too wide to let just it run wide. So the recommendation has been that come January 2022, the e-commerce operator would be within the e-commerce operator would include an operator such as a Swiggy, who is enabling or the provision of restaurant services, whereby Swiggy would then become responsible to collect the entire tax that the underlying restaurant suppliers of services is responsible for, and make good that tax to the government. By virtue of that, effectively the government has sort of brought the, I would use the word headache onto the middleman operator, app operator, which is the e-commerce operator, who is responsible to make the tax payment. And by virtue of that, the monitoring, the leakage will all sort of get addressed, because there's one point of contact from the government's point of view, and the entire tax collection should happen at that point in time, at that point itself. So there should not be leakage from there. From there. Now, just very very briefly touching upon the current position, the e-commerce operator is required to mandatorily register and collect tax at source. That is but situation obvious. The supplier was also required to mandatorily register and discharge tax when making supplies through an e-commerce operator who collects tax. The reason for this is obvious, that if there was tax collected at source, the credit for that should have to be taken, enjoyed, and set off. So as then the situation would be, you don't have to pay that much double tax as the supplier. Now, the change that is likely to happen in the context of the food business, in the context of the restaurant business, is that the e-commerce operator will now collect the entire tax and pay it to the government, effectively, like I mentioned, on behalf of the supplier. And then it may so happen, and this is something that we wouldn't be very clear about at this moment, because the mechanics of this is still to be pronounced. The restaurant may not be required to mandatorily register, and the reason for that is quite logical, that if the tax is completely paid out by the e-commerce operator, there is no requirement or there is no need which or purpose which will be served by the underlying restaurant to have its registration, because there is no TCS that it needs to take care of. There is no other thing that is liability, so it may not necessarily have to register, and that's perhaps the way in which it will play out. No, while all of this is something which will develop, we'll have to wait and watch and see how the government formulates the procedure, the mechanism, and the system for taxation of this sector, especially in the restaurant business. There is some food for thought in terms of certain issues. What is the scope of the expression supplied through it? Where I'm an app and I offer you a reservation capability and maybe bill, payment facility through when you visit a restaurant or an eating house, is that a supply made through it? that's a question which has also arisen in the context of radio taxis. It was addressed by the advance ruling in Karnataka by saying yes, it is. And so, if that conclusion is taken even here, we'll have a liability to pay tax even when you're merely offering a reservation platform and or you're offering the ability to sort of make payment of the bill, even though you don't necessarily order through or from that particular app. Uh, our next question that comes up, this is again because of the way in which e-commerce operators are placed, is what is the availability of input tax credit for an e-commerce operator? Now let's look at the underlying restaurant services. They are liable for 5% GST without ITC. Okay, but in certain situations, for example, hotels with a tariff, or in case of certain rooms where it's in excess of 7,500, they would have the ability to go at the 18% rate as well. They can enjoy credit. They would be at 18%. Now, when the situation is that the e-commerce operator from January 2022 will be liable to pay tax and on behalf of these restaurants and these eating houses and these hotels, etc., uh, how will the credit flow occur? Because the hotel is also going to have certain amount of its credit. So what happens to that, and how does that get sort of used up, or does that get sort of diluted and lost out? In that case, is there a dilution of the concept of cascading of tax on tax concept, and therefore ITC is lost out? Um, Difficult to tell at this moment. We'll have to wait and watch. What may also have to be borne in mind is that as the particular e-commerce operator is concerned, he has his own supply. So he's basically maybe charging for the facilitation, for the facility, for the app, for the benefit of you're not having to do anything more than lift a finger. And for that particular service supply, he has his own charge. Now, he has his own charge, he has his own setup, he has his own costs, he has his own ITCs. Now, what will happen? Whether they will be able to, or they will have to keep a silo of those credits, of those taxes that it pays as its own supply versus what it pays as a supply made for another person, which is restaurant in this case. How will that demarcation be made? What will be the flow for credit in that? Can there be a mix and match of these amounts, or so to speak? Uh, Again, some things which are not capable of being addressed today, questions that are there, but we'll have to see the mechanism of that particular provisions as to how it operates. The reason why, of course, somewhere they've given them Jan 2022 is because there will be quite a wholesale amount of changes that will be needed. The IT systems will have to be overhauled. There will be issues maybe in relation to pricing and payment of tax. How will you have the invoicing carried out? What happens in cases where a restaurant may have its own e-commerce channel? I'm told someone like a QSR, a quick service restaurant like a McDonald's, has its own e-commerce facility. In that situation, would there then be a requirement to say that the e-commerce operator pays, or is it just one entity and so it doesn't matter? Again, things that will need to be clarified as this model goes into effect. What would happen in the case of supplies by an ice cream parlor or a bakery, where now in this particular GST meeting itself, it was clarified that ice cream parlors are to be taxed at 18%. And if that's in 18%, then there is also credits. And in that case, then how will the e-commerce operator be required to sort of discharge that tax? And what happens to the credits that is there underlying, the ice cream parlor in question? So these are all open points that are there, and I think may not be worthwhile getting into a debate one way or the other at this juncture. We should wait for the fine print of it as and when it comes out, and then we'll be able to make a more informed sort of analysis of the provisions. Yeah, so with that, I've covered up on all the key changes, the prominent ones that were there, and so one, you can you can summarize this as saying it's quite an eventful GST Council meeting that we had on the 17th of September. Quite a bit of post action has also been witnessed. We've had circulars, like I said, we had notification last evening. and there will be more which will come through because of those recommendations. So while it may seem that several of them changes are not concerning a lot of the cross section of the audience, there are a lot of developments that have occurred, and in times to come, I dare say we will have equal and more sort of changes and recommendations that we will have to sort of deal with. So with that, I'd like to thank you for the patient listening that you've given me. Thank you.
Thank you so much, sir. Indeed, it was a very beautiful explained the entire rulings, the current context, background, and I think after hearing the discussion, I think we all have benefited, and it was a detailed discussion. We have gone through the provisions, ruling, etc. So it was definitely very useful. We have some questions in the chat box. Would you like to take it now? I think maybe a few questions, or I think we have already crossed the time. So maybe one or two questions, if you is it possible?
Yeah, I'm just taking a look if it's possible. Time also is a bit of a constraint. So there's one question which says, is refund of ITC possible upon winding up of the company? I'll just take that one up because that is a specific sort of clarification or actually an amendment which will come through. The answer to that is, Ravi Tela, that it's not possible for the balance which is in the credit ledger because there is no provision for it. But what is in the cash ledger, yes, it can be refunded. What has now been recommended is that there will be a ability to have that transferred also from one jurisdiction to another, and that's a useful change, I believe. So it's a situation where if you're winding up, even in the pre-GST regime, there was a controversy. There have been some judgments which have said you can take the benefit of claiming the refund of the SENVAT balance. The later view has been from the judicial side has been not. So yeah, that's the response that I have for that one. All right, Ira. I think we can take up the other questions maybe offline in a direct way.
Sure. I think some of the questions are already answered when you were taking up the issues and all.
Yes.
So definitely it would request all the participants. We have noted the questions. Maybe you can just send us the questions in mail to us also, so that we can accordingly take it up. And because one particular question with respect to the rate of royalty, which is like where there's a clarification on regarding 18%. So I think that Mr. Amit Chaturvedi, just a second. Amit Chakrabarti has dropped in a message. So we are also in touch with our other members. So just a request, maybe you can send it to us in email. We'll take it up separately. And thank you so much, sir, for this presentation. And it was a very useful presentation. There were a lot of insights, and we are now more clear with the what all has happened in the meeting of the GST Council. So hopefully all the participants, they have also benefited from the discussions today. We will be sharing a copy of the presentation with all the participants. And in case there are any queries, please do send your queries to us via email. We'll try to send it to Mr. Ranjit Mahatani also, and maybe that can be taken up separately. So thank you everyone for your time, for joining us today, and we look forward to more such interactions in future. Thank you everyone.
Thank you. Have a good day. Bye bye.